Hello, we are transmitting live from San Diego, California in the studios of KPBS on the campus of San Diego State University. Greetings to our participants in Canada, Mexico, the Dominican Republic, Costa Rica, Panama, Colombia, Ecuador, Venezuela, Peru, Paraguay, Brazil, Bolivia, Argentina, and of course the United States of America. Our U.S. and Canadian sites are being reached thanks to the Public Broadcasting System's PBS Adult Learning Satellite Service located in Alexandria, Virginia. Welcome. We would like to thank once again Telecomunicaciones de Mexico, Panamsat, Brasilsat, ANIC E2, Nahuelsat, and Telstar for their satellite linkage services which allow us to reach all of you directly through the wonders of telecommunications. We also acknowledge the initiative of and program support provided by the U.S.-Mexico Conflict Resolution Center at New Mexico State University, located in Las Cruces, and the invaluable leadership of its director, Nancy Aretskin. Today's video conference, entitled The Effective Management of International Conflict, the Strength of Diversity, is the third and last program of a three-part mini-series entitled Conflict Management and Dispute Resolution. The three programs, the titles of which you can find in your participants' manual, constitute an integrated series of presentations covering the application of the alternative dispute resolution techniques to international situations. Further development of these themes will take place during the 1997 International Training Center, or ITC, series of programs. As part of next year's series, 2 programs will be offered on alternative dispute resolution and its application in international trade and in commercial diplomacy. Each of you is encouraged to sign up to participate next year. Today's program is comprised of 3 presentation modules and 2 question and answer sessions. We look forward to your live participation. As you know, my name is Richard Page. I will be your moderator for today's program. I am a private attorney with the San Diego law firm of Page, Poland, and Bush, practicing in the areas of business and international law. I am the head of the firm's litigation and international departments. Today's program will focus on the process of mediation, which is the consensual resolution of disputes using an independent third party, known as a mediator. Many experts in the field of dispute resolution feel that this is the most effective technique being used today. In addition, many believe that cultures outside the Anglo-American common law system are less litigious or likely to sue in court before entering into settlement discussions. Therefore, the use of mediation will develop more rapidly in Latin America than in the United States and Canada, and that American practitioners will have much to learn from the observation of mediation in Latin America. In a trip which I made to South America in August, I became aware of a new law in Argentina which requires mediation between the parties to a dispute before they can proceed in court. In addition, Brazil is about to enact a revised arbitration law which will recognize foreign arbitral awards and facilitate the acceptance of such awards by Brazilian courts. The advances which are being made in Latin America are extremely encouraging. Hopefully, continued communication regarding all of our mutual experiences in alternative dispute resolution will lead to techniques which will be accepted throughout the Americas and the rest of the world, and which will allow for better ways to resolve our international commercial disputes. It is my pleasure to introduce to you today's guests and expert speakers, the Honorable W. John Brennan and Mr. Charles A. Cooper. A little later, you will meet the Honorable Harry R. McCue. A sincere welcome to each of you, and thanks for being with us. Our first presentation module will be given by the Honorable John Brennan. Judge Brennan is Chief Judge of the 2nd Judicial District Court in Bernalillo County, New Mexico. He is a graduate of Notre Dame University, where he received his Bachelor of Arts degree in 1969, and of the University of New Mexico School of Law, where he received his Juris Doctorate degree in 1973. Judge Brennan is the chairman of the New Mexico State Bar's Alternative Dispute Resolution Committee. He has been a member of the New Mexico State Bar's Judicial Selection Committee since 1982, He also initiated the arbitration project in Bernalillo County and a program called Settlement Week, designed to help facilitate the resolution of cases through settlement conferences. He has received degrees from the National Judicial College in General Jurisdiction, Alternative Dispute Resolution, and Judicial Settlement. He has also received the Outstanding Judge Award from the New Mexico State Bar Association. Judge Brennan, before we begin, I'd like to ask you the following question. Do you see alternative dispute resolution, or ADR, as a threat to the court system?
Richard, as I think you know, alternative dispute resolution has been a tremendous benefit to the court system. Each judge in the state where I come from, New Mexico, usually has over 1,000 cases pending before him or her. And as a result of that, it takes a long time to get to trial. We have initiated many alternative dispute resolution programs which take these cases off the docket, and as a result, most of our dockets are not as crowded as they used to be. In addition, we find out that the parties would rather settle their dispute through mediation or arbitration than through the trial process. So it's been a great benefit for our system, not only in terms of relieving our docket, but also in terms of party satisfaction. The parties are much happier when they resolve their dispute through a mediation or an arbitration.
Our second presentation module will be given by Chuck Cooper, who is the Senior Vice President of the American Arbitration Association. In that capacity, he is responsible for the recruitment and training processes of the association, for consultation in the design and implementation of grievance and dispute resolution systems for international businesses, and for the effective administration of the 13 Western offices of the association. He is also a founder and the director of the American Arbitration Association's Asia-Pacific Center for the Resolution of International Business Disputes. He has trained arbitrators and mediators for business and insurance disputes throughout the United States, in Australia, Malaysia, Singapore, and Hong Kong. Mr. Cooper has produced and directed many videotapes on arbitration, mediation, and arbitrator training. Before we begin, I would like to ask Mr. Cooper the following question. Do you believe that the mediation process, in that process, we will see more use of it in international commercial disputes? And is the increased diversity in our society and the growth of international partnerships also a factor in the increased importance of this strategy?
Yes, I do. I think mediation is particularly suited in disputes and problems involving cross-cultural issues. The growth of mediation in the United States and in Australia is very heartening to us, and of course, as you mentioned, there's a tremendous growth in the use of mediation in Argentina, and we believe there will be, with NAFTA and other bilateral trade agreements, a growing use of mediation in international trade.
Thank you, gentlemen. Let's begin now with the first module, in which Judge Brennan will explain the advantages of and importance of using mediation as a dispute resolution mechanism.
Thank you. I'm a judge in Albuquerque, New Mexico, and I've been on the district court bench for approximately 17 years. Albuquerque has a population of around 600,000 people and is the district court of general jurisdiction. As the court of general jurisdiction, we handle criminal felony cases, domestic relations cases, and all types of civil matters, primarily personal injury matters and contractual disputes, including employment problems. Today, I intend to discuss my experience on the bench in terms of dispute resolution, and will suggest that mediation is the best form of dispute resolution, and as such should be considered by anyone involved in international dispute resolution. When I first started resolving disputes on the bench, the only method available in our community was that of a trial. As a result, lawyers would file cases and be placed on a trial docket and eventually come to court before a judge or a jury who ultimately would decide how that dispute would be resolved. In the process, of course, many of the disputes were resolved informally between the lawyers, but usually not until the last minute. It became apparent to me and others that there were many problems with this form of dispute resolution. The primary problems, of course, were the fact that it was very expensive and took too long to get to court. It became clear that parties involved in disputes, particularly under $25,000, were spending money on attorney's fees which far exceeded the value of their claims. In addition, it frequently took more than 2 years to get to a trial because of the large number of cases on a judge's docket. Every judge in our county would frequently have as many as 1,500 cases pending before him or her in a particular year. In California, in the early 80s, it was so bad that it would take 5 years to get to court after the filing of a complaint. Some lawyers even started specializing in getting continuances because once a continuance was obtained, you would go to the end of the docket and thus avoid a hearing for many years. It was Voltaire who once said that 2 bad things happened to him in his life. One is he got involved in a lawsuit and he lost. The other one is he got involved in a lawsuit and he won. No doubt he was referring to the fact that even when a party wins, because of the length of time, the expense, and the emotional energy expended in lawsuits, that even the winner turns out to be a loser. It was also former Justice Warren Burger of the United States Supreme Court who said, and I quote, "People with legal problems are like people with pain. What they want is they want relief, and they want it as quickly and inexpensively as possible." It became clear to those of us involved in the judicial system that it was time to examine other methods of dispute resolution. And it was about that time that I was exposed to the concept of mediation. There are many definitions of mediation, but mediation is basically a form of dispute or of settlement negotiation in which a trained, neutral third party intervenes at the request of the other parties to a dispute in order to guide and facilitate the parties' negotiations towards an agreement that ends the dispute. In explaining mediation, I try to use a continuum of dispute resolution processes. As you go up this continuum, the parties themselves continually lose control over the process. This is, of course, something most parties strive to avoid. We start off with negotiation, which offers the highest degree of control for the parties, in that it is a communication between the parties themselves in order to try to resolve their own dispute. After that, as we go up the continuum, we come to mediation/settlement facilitation, which involves a third-person neutral coming in a non-binding capacity to help the parties reach a resolution of their own dispute. After that, we have arbitration, in which again a third person comes in, but this third person actually decides how the dispute is to be resolved. Arbitration is very similar to litigation, but the process can be worked out contractually so that it is less formal and hopefully less expensive. Finally, in the continuum, we come to litigation, which historically has been the way most disputes in the United States are resolved, and involves coming before a third person or entity, such as a judge or a jury, who actually ends up deciding the dispute. You may ask, why is it necessary to have a mediator? Again, in looking at the continuum, if negotiation does not produce a resolution of the dispute, it is obvious the parties are unable to resolve the dispute amicably on their own, and are unable also to narrow the issues to define a manageable set of issues. A third party is thus brought in to furnish the parties with a realistic and impartial look at the issues involved and offer possibilities for resolving them. This avoids further negative consequences, and hopefully the third party is able to act as a confidential conduit of information between the parties without jeopardizing their original positions. I was recently involved in a mediation in which a prisoner was suing his former lawyer for legal malpractice. The parties were unable to negotiate their differences, and the case was referred to me by another judge in our district. During our confidential caucus, it became clear to me that the lawyer had indeed been negligent in his representation of his client, but that he was unwilling to admit it in writing for fear of being sanctioned by the disciplinary board of our bar association. As a result, we finally compromised the matter by having the lawyer verbally apologize to his former client and agree to return all monies which were given to him for his representation. This, of course, could never have happened in the more formalized adversarial process such as a trial, and yet it was a satisfactory resolution of the dispute to both parties involved. So what are the advantages of mediation? I would list the following as being the primary advantages. First, mediation typically resolves disputes faster and less expensively than more formal methods of dispute resolution. Second, mediation can help relationships that could not survive confrontational conflict management processes. Third, mediated settlement disputes are jointly shaped and mutually agreed on by the parties, and as such the parties do not lose control. And last, mediation allows for more flexibility because the parties are frequently allowed to shape their own resolution of their disputes. It should be pointed out that mediation is not a new concept and has been used by other nations for centuries. For example, the Navajo Peacemaker Court, which I recently attended in Windrock, Arizona, was very interesting. In this court, they do not have a true mediator, but rather a third person, usually a tribal leader, who comes in to preside over the dispute. In addition to the disputants, many times other leaders in the community are invited in, along with family and friends. In the Peacemaker Court, a mutually agreeable solution is worked out and agreed to. The parties are then expected, because of tradition and community pressure, to abide by the agreement. This process has worked successfully in the Navajo Nation for centuries. As a result of studying mediation and dispute resolution, we decided to experiment with it in the Bernalillo County District Court. And we required in 1982 that all domestic relations disputes and neighborhood disputes be referred to mediation. Mediation became a mandatory method for parties seeking a divorce who had to deal with issues of custody. And in our metropolitan court, we required people involved in neighborhood disputes to participate in mediation. We decided to concentrate on these areas initially because these parties needed to have continuing communication with one another, and we felt this process was the best one to help maintain that communication. In the first 10 years, our statistics show that 68% of these disputes were resolved in mediation. In 1988, we instituted a form of mediation called settlement facilitation for all civil cases in our district court. Settlement facilitation is a form of mediation in which the third-party neutral gets more actively involved in promoting settlement. We set up a one-week period of time in which all of our civil disputes were referred to mediators or settlement facilitators who would sit down with the parties in an informal environment after being trained by judges and other facilitators and would attempt to get the parties to resolve the dispute. It became clear that after a period of time that almost 75% of these disputes were either resolved at the settlement conference or shortly thereafter as a result of these conferences. From 1988 to 1995, several thousand cases have been referred by the district court to settlement facilitation, and the majority of these have ended up settling as a result of this process. As part of the process, we sent out questionnaires to the parties involved in the dispute. Although some of them did not settle their dispute, at least 95% of all the parties responding in each of these calendar years agreed that it was a process they enjoyed participating in and would engage in the future even if they didn't resolve their dispute. If you compare this party satisfaction with typical litigation, it is understandable why many of us involved in the judiciary have committed ourselves to this mediation process. As a judge, I have engaged in many mediations over the years. I make it a point of not taking cases of my own because I might become aware of confidential communications. But I have handled hundreds of cases for judges in our district, and I can tell you without hesitation that party satisfaction is much more likely to be achieved through a mediation than through the formal process of litigation. I recall vividly a mediation I handled in which a man who had lost his leg in an accident and was unable to negotiate a compromise with the insurance company came to mediation. At the time of the conference, he was able to come in and tell his story to the insurance company and to me, and to exchange views and to eventually reach a compromise. When he was leaving, he took me aside and began to cry, and he thanked me for this resolution of his dispute. He told me that the process gave him the opportunity to come in, tell his story, and although he didn't get everything he wanted, at least he received what he felt he could live with. He was able to do this in a way in which he saved time, expense, and embarrassment. We should remember that the lack of formality to the process allows it to be conducted outside of public view and with complete confidentiality, and this certainly benefits the parties. It is becoming clear that not only parties, but lawyers are beginning to understand the advantages of mediation over litigation. In the recent American Bar Association journal dated August 1996, a poll was taken of lawyers throughout the country, and it was found that 51% of the lawyers favor mediation over litigation for resolving disputes, whereas only 31% prefer litigation. When the choice is litigation or arbitration, 43% prefer litigation and 31% choose arbitration. I think this is probably due to the fact that many arbitrations end up having many of the problems that a person experiences in litigation. I would therefore again suggest that mediation is the process and the best method for dispute resolution for the reasons I have just cited. In international disputes, it is particularly important to choose a mediator who has not only been trained in mediation, but also has some familiarity with the social, historical, political, and cultural backgrounds of the parties involved in the dispute. It is important that all of you who are involved in business who want a resolution of your dispute quickly and inexpensively, that you place mediation clauses in your contracts. In the event it is unsuccessful, then you may rely on more formal processes such as arbitration and litigation to resolve your dispute. There is no less of an authority than the former President of the United States, Abraham Lincoln, who many years ago said, and I quote, "Discourage litigation, persuade your neighbors to compromise whenever you can, point out to them how the nominal winner is often a real loser in fees, expenses, and waste of time." It took me many years to discover this superior method of dispute resolution, and I would urge all of you to give it serious consideration in dealing with your disputes. Thank you.
Thank you, Judge Brennan. Before we get to the first question and answer period, we will continue with Module 2, in which Mr. Cooper will tell us how to prepare for mediation.
Thank you. I would like to start by telling you a little bit about the organization of which I am a senior vice president, the American Arbitration Association. I am also our national mediation coordinator. The association was founded in 1926 as a private, not-for-profit organization dedicated to establishing and maintaining fair and impartial procedures for dispute resolution as an effective alternative to the courts. Over the past 70 years, our reputation for efficient, inexpensive, and neutral administration of the dispute resolution process has spread worldwide. In 1995, over 2,500 mediations were filed with the association in the United States. This is in addition to the more than 59,000 arbitration received in that year alone. What this tells us about the American use of alternative dispute resolution is impressive. Those 62,000 cases equal 1/3 of all civil cases filed in all of the federal district courts in the United States. Whether in a formal mediation session or during the everyday conduct of business, a wise conflict manager understands and utilizes the value of mediation. The benefits of mediation as a dispute resolution option, which include preparedness, control, flexibility, self-determination, and improved communication, and the attendant savings of time, money, and relationships, necessitate that the international conflict manager pay close attention to mediation. In the balance of this program, we will explain how to receive these benefits, how you can be prepared, keep control, stay flexible, retain your rights to self-determination, and improve communication through the use of mediation in international business. There is currently much debate in the legal community between parties, advocates, and mediators over whether pre-dispute mediation clauses should be included in commercial contracts. Although mediation has been used for quite some time in labor management and other disputes, it is a relatively new method to resolve, for example, commercial, construction, or insurance disputes. As such, the practice has been that if mediation is discussed at all, it is only after a dispute has arisen. Since mediation is a consensual, non-binding process where anyone can walk away at any time, many believe that a pre-dispute mediation clause is unnecessary. A pre-dispute mediation clause, however, is often extremely valuable to the parties since it ensures that they will at least come to the table and give the process a chance. If only given a chance, the statistical success rate for reaching settlements is extremely high. More than 85% of the commercial mediations conducted by the American Arbitration Association result in a settlement, generally with considerable savings in trial preparation. It is a generally accepted premise that mediation works. Many mediators and mediation agencies have observed that the most difficult part of the mediation process is to get the parties to maybe. In other words, to convince the disputing parties and their counsel to agree to try mediation in the first place. Though this may seem odd in light of the high success rate of mediation, there is some explanation for the hesitancy. Mediation is still an unfamiliar process to the uninitiated. During times of stress, which most people experience while involved in a dispute, individuals tend to react critically to the unfamiliar. The records of any mediation agency or private mediator are filled with cases indicating that parties or lawyers who are familiar with the benefits of mediation tend to use it repeatedly. Many people, even experienced lawyers, hesitate to suggest settlement discussions to the opponent. The one who blinks first in a dispute is considered hesitant and is often viewed as the person who holds the weakest hand. The parties to a dispute may feel that being the one to offer mediation may indicate fear or panic, and for that reason will avoid making any such suggestion. There are two possible solutions: a pre-dispute mediation clause or the use of an agency to bring the parties to the table. These two solutions can be combined to create a powerful tool to establish the right climate to fashion creative solutions to business problems. CAMCA, the Commercial Arbitration and Mediation Center for the Americas, was created by the leading arbitration institutions in Mexico, Canada, and the United States to fulfill this purpose. Information on CAMCA can be found at the American Arbitration Association's webpage. A pre-existing mediation clause, which requires the parties to meet and discuss the dispute in good faith in the presence of a trained mediator, will avoid any stigma, real or perceived, for suggesting mediation. Thus, rather than appearing to have a weak case, the suggesting party will merely be complying with the terms of the contract. A pre-existing mediation clause, or the use of an institution, allows the business executive or lawyer to fashion a process to meet the needs of the client, as well as the concerns of the others involved. The pre-dispute mediation clause is a sub-agreement contained within another agreement between the parties, such as a commercial or construction contract. The clause specifies that the parties will mediate their claims in the event that a dispute arises. The pre-dispute mediation clause, by definition, is drafted before a dispute has arisen. It can specify that the mediation will take place at any particular mediation organization, and if so, the rules of the organization will be incorporated into the agreement. A sample American Arbitration Association standard pre-dispute mediation clause reads quite simply: if a dispute arises out of or related to this contract or the breach thereof, the parties agree first